says. I tell you, court gave me two big things, a job and him.
Will you buy his plate first? Let's go.
Okay, we're ready.
Ready?
Okay, let me ask you, I was asking you about finding lawyers.
Yes.
Have you ever seen it done?
Don't think I have.
You ever heard of it being done?
Yes.
Okay. Do you know of any law or statute that gives a judge the right to find a lawyer?
No, I do not.
Do you know what happens when a lawyer is fined, let's say he gives money to a judge? What would you do with the money?
I don't know. I think the only one I heard of, I believe the attorney told me that he had to write it out to some charities. I don't know.
Okay. So, what's, you're sitting on the bench, you gonna find any lawyers?
I don't think of any circumstances where I would. I think a lot of people get to court a little later, dropping the kids off, whatever. I think most people.
Have you been a sole practitioner most of your life?
I was a sole practitioner for 7 years.
Okay. So, you know lawyers have to make a living, right?
Yes.
And a lot of times, you'll have a hearing, let's say in Middlesex, and you get a new date to come back, and then in the meantime, a new client comes in. Because I got a case up in Essex, it's on the same day.
Right.
So you go to Essex first, and you call the court and say you're gonna be late in Middlesex, right?
Right.
You got any problem with that?
No, I don't. We frequently let the other lawyers know, or even call the court to let them know.
Sometimes the lawyers let the other side know.
Yes, I had to finish, say, making revisions to an agreement, the other attorneys there.
So you got, what, maybe 60 cases now in every probate courtroom in the morning, 50, 60 cases.
Right.
So you're gonna be there before 4:30, right?
Right.
So whether you do case Mr. Jones and Mrs. Jones at 9, or you do it at 4 or 3, isn't gonna make much difference to you, is it?
No, it's not.
So keep that in mind about lawyers, they gotta make a living, pay
Yes.
the bills. Not, they don't have a salary or a pension or anything.
Right.
So, let me ask you a question here. At what age can you contract to be married in the county?
I think if you're of age of 18, I believe if you're 16, you need consent.
Sure about that?
I think so, I'm not sure. I
Did
know
you
you get
study
married.
that before you came in?
No, I didn't, but I only know this because I was appointed to represent a woman, a young woman with a child.
At what age, what's the waiting period before you can get married?
I think there's a 3-day.
You still have to get a test for communicable disease?
No.
They did away with that? What are the grounds for divorce in the Commonwealth?
There are fault grounds and no fault grounds. No fault grounds are good to break down, and that's the most common. Fault grounds are desertion, intoxication, cruel and abusive treatment, cruel and refusal of support.
What about if you get sentenced to prison?
Prison is one of them. Did I say intoxication? Infancy, prison.
So we used to have, you weren't practicing, you didn't have no.
Right. It's always
So what happened is you had to come in, you had to make up a reason to get divorced.
yes.
So you were asked by a judge to raise your hand and tell the truth. And then they asked, usually the woman, when you got married, what was your weight? How was your demeanor? Oh, it was great. Did you suffer from anything? No, it was great. Good health. So for the last 6 to 8 months, how's your health been? No, it's been bad. I'm nervous, can't sleep at night. And the judge would find cruel and abusive treatment because that was marriage causing. And everybody in the room knew that the woman wasn't telling had to say these things in order to get divorced.
Right.
So one of the reasons no fault was, it didn't seem right to have people straight tell the truth, and you never you weren't telling the truth.
Right.
So now you don't have to do that, right?
Correct.
You like no fault?
I do. I sometimes think that parties want punitive damages, and maybe if we had a room with nerve bats, it would help, but I'm further no fault.
Is it still a ground for divorce adultery?
Yes,
It's still under motion?
yes, it is Massachusetts.
Who can make service in a divorce action?
Either a sheriff's office or constable.
Can an attorney file a motion for someone else to do it?
You can file a motion for a process server that will be authorized, or you can do alternative service publication. There are other things, but generally it will be a constable.
Do pro se litigants in probate court have a right to get a court-appointed lawyer?
Not in the probate might be some case law that there are unusual circumstances regarding children's issues, but not in probate.
Have you ever been a master in the probate court?
Yes.
What is that?
I've been a master of discovery, and I've been a master of
No,
division of assets.
you gotta listen. What does a master do?
A master would hear matters outside the court between the parties, so that render a decision by the court, so that the parties might avoid lengthy court.
What kind of cases would they be involved in?
They might be discovery matters, they may be asset cases, issues of valuations of businesses.
What's the jurisdiction of the probate?
The probate court hears all matters regarding domestic relations such as divorce, paternity, child support, custody, parenting time. On the equity side or equity complaints, the probate matters with guardianships, conservatorships, also adoptions, termination rights, petitions to partition, administration of the states.
So they handle the states.
Yes.
And does the Superior Court have concurrent jurisdiction of the divorce case?
The Superior Court is equity, something with jurisdiction, but not a divorce case.
What did you think of the new alimony law before it was changed by the estates?
Overall, I thought, for the most part, it's very helpful for us as litigants. Prior to the alimony statute, we had no parameters in order to settle cases, in particular, say, for midterm, short-term marriages. So the durational limits then helped us regarding settling matters, so the parties would be comfortable with alimony figures. Also, the amounts was no longer the luck of the draw on which judge got filed. It was more, we had some guidelines to go by to see if we could come up with.
Is there anything you didn't like about it?
There are cases that had to test the alimony statute because parts of it weren't clear, whether it was retroactive, whether it was prospective. Also,
Or you didn't like that about it?
no, I thought I didn't like it, but I mean, there were some problems with it, but again, it made room for argument, and there were cases that went to the appellate court on that. The other thing is, there's still a need basis. So I think that some people, attorneys and judges, when they look at the statute, they think they're automatically supposed to come up with a figure between 30 and 35% of the income differential, but there's still a need component that is, people seem to.
Okay. You indicated that joint custody is something you're in favor of.
What, in custody is part of jurisdiction, what you mean with parties?
No, first,
Oh,
you
previously,
first.
Counsel Ferrero, I think there's a presumption of joint legal custody.
So does that mean when you call the case, Mr. and Mrs. Jones, court's been, first time they're in the court, they're walking up to the court. In your mind, at that point, they're both entitled to equal visitation? I shouldn't use visitation, child.
Well, what happens is, most likely.
No, my question is, as they're walking up to the bench, before anything is said, you have the position in your mind, I'm until I hear something different. They're both entitled to equal, child custody.
I don't think I'm thinking anything. I would have hoped I would have read what was before me before the case was called.
Well, isn't it, the presumption is they're both entitled?
There's a presumption under the statute of joint legal custody in a marriage, not in a non-marriage.
Well, we're
So-
talking about marriage.
Right, okay.
So if that's the presumption, you have that presumption, don't you?
You have the presumption of joint legal custody, but there's no present presumption of joint physical custody in Massachusetts.
Why wouldn't you have that same idea when they're walking up?
Because under 2-way-31, we're required, the statutes of 2-way, we're required to render decisions in the best interest of the children, not the
No,
parties.
you're not listening to me, you're missing the point. You haven't heard any evidence yet. Right?
Right.
Two people walking up to your bench. Is in your mind, until I hear something different, I'm gonna give joint custody, I'll hear the evidence, and I may change my opinion.
If I haven't heard anything yet, I
Right.
don't think I would be considering an issue of custody at all.
Even though you read the files and you've got kids.
I think I have to hear what was going on.
Well, that's what I'm saying, but until you hear, why wouldn't you say, I'm gonna give both of them are equal, till I hear something different?
I don't think it would be appropriate for me as a jurist to make a determination such as that prior to any testimony, hearing, looking at it. I don't think it would be appropriate to predetermine. I don't think the statute allows.
And, would you be in favor if the parties, had no issues, they were both good mother and father, having a split custody for the week,
Most likely, yes.
3.5?
Yes, let's say there are a couple of involved parents, they have a couple of kids, midterm marriage, they both work. Generally, that's the result. Both are able to work on a shared custody plan.
You wouldn't have any problem.
No, I've had some.
What's divorce in 9 seconds?
It's the final period, so when parties get divorced, they become final in 90 days under 1B, 120 days in 1A. In other words, it could be matters that are coming in prior to that regarding dissolution. Perhaps the parties get back together or something. So there's a 90-day or 120-day final period, and that's what that means.
Have you ever heard of parties getting back together?
I have, a couple of my clients have done so, and I've been in court before a couple of times, so we have this dismissed.
So I'll tell you a very quick story about a couple of friends out in Western Mass. And they weren't getting along, they didn't have any kids. And they got divorced. They had the 90 days back then.
Right, under 1B.
So it was 90 days. On about the 84th day, the husband died. The husband was half owner of the O'Connell Construction Company in White Oak. 5 companies around the world. About $240 million. They were divorced.
I've heard about things like that happening. It's quite unusual.
Jimmy Joe? Huh? Jimmy Joe. Try to narrow your ass. What's the burden of proof in a divorce trial?
Well, what happens is, in a divorce case, you have to show abundance regarding what the ramifications are.
Okay, so it's preponderance of the evidence.
Yes.
And if you have, if you have somebody you know is illegal in this country, what are you gonna do about that?
Well, if you're talking about, I've had cases of juvenile special circumstances cases that.
No, let's say you have somebody before you, you find out that he's illegal,
The,
you're gonna call INS?
the Supreme Judicial Court has granted a decision on that. The lower court, probate court does not issue decisions on that matter. And it comes to the federal court.
Are you gonna call INS?
No, the federal court is Part of this immigration work.
That was a nice answer, Bob.
That
Still got one along.
One of the best answers I've heard.
was an honest answer.
I'll call Margaret too.
You have restraining orders in the, if you're doing restraining orders?
Yes, I probably most likely represented more defendants on restraining orders and complainants, but I've had cases in both probate court.
Okay, so you got two people standing in front of you, they want a restraining order, you don't know them, they both testify one way or the other. How do you make that decision? Who's coming?
I think you listen to what they have to say. Hopefully, both parties testify. Sometimes only one party testifies. I think you would be assessing listening to what they have to say, any documentation they have, police reports.
Okay, but how do you know what they're saying is true?
Well,
Would you agree with me that a percentage of, at one point, it was 45,000 restraining orders in the Commonwealth, and it was estimated that a third of them were untruthful testimony?
I think
How do you know
that,
the time?
well, as I said, you issue the decision best you can. What usually happens is, in my experience working in defense, I have to read the affidavit, and I say, what do you think of this? And they say, well, yeah, that happened. She knew, like, I wasn't a hurt, she should have been afraid. What I have experienced is they frequently have a different interpretation of what happened. It's not that they might be
Right.
out of line. I do think that you get more here in probate court, and I'm sorry to Judge Mary Hurley, that's here in the district court, but I do think that you get more hearing in probate court than you do in the district court.
Okay, but you would agree with me that there are times when people fudge what's happening in these cases?
I think sometimes
Get the
they do.
restraining order?
I think sometimes they do, but I think the determination is, does the person have in fear?
Right. Well, we know, don't we, you know as a lawyer that sometimes somebody tips off one of the parties to say that.
Right.
These are the magic words, I
Right.
didn't fear for my life.
Sometimes they don't even say it, the judge should say. I've seen that.
And that's a tough thing sometimes if it's issued, right?
Right, it's very debilitating. People, they can be prevented from adopting children, they can lose their jobs, I can find some lots of jobs. All sorts of ramifications can occur. It's a very serious issue.
So someday we're gonna have a gizmo in your court, they're gonna put their hand in, it's gonna say T for S, okay?
We've talked about that. I know.
I don't have any more questions, thank you for putting up with me, and, you got a lot of good work.
Council Iannello, then Council Devane.
Thank you. Someone owns property. Spouses own property jointly. They own the property jointly. What does that
It could mean that the titles in both of the names, or it could mean that it's a joint marital asset.
mean? Let's assume the title is in their name. What does that mean with respect to divisions? I mean, they own it 50.
Own it as tenants by the entirety, if married.
I understand that,
You would most likely look at it as a 50-50 division.
right? And we could have a tenants in common, or we could have a joint tenants.
Right.
Joint tenants.
Yes.
So if somebody owns a piece of property, if I have a piece of property, joint tenants with Bob Jubenville, don't we own it 50-50?
I think the statute of frauds would dictate that they did, but there might be circumstances where contribution comes into play, whereas one party might be alleging that he or she contributed much more to the down payment or to the maintenance of the property. than the
But
other.
generally speaking,
Generally
it's
is.
50-50.
Generally is.
I've heard these terms today. We hear them all the time. Joint physical custody,
Right.
joint legal custody. If we had a secret poll amongst everybody here, I bet you a penny that they believe that joint physical custody and joint legal custody means both parents have 50-50. And that's not even close to being true. Is that correct?
Right, I think that would be
Right?
the.
Right? It's not true.
That would be the meaning.
So when you say joint, you have a joint checking account. You think you have a joint checking account with your spouse or your sister? It's both of us. It's 50-50.
Right.
But let's talk about joint physical custody. What does that mean? Everyone in this room. What does that mean, joint physical custody?
Usually means that the children are with each necessarily exactly 50/50, but close enough.
Oh, so I didn't realize that, and that's why I haven't heard that before, just to let you know that.
Okay.
So someone could have, so say someone has 75% of the time, someone has 25%, you would not call that joint fiscal custody?
No,
Okay. Would you call it joint legal custody?
if they were married.
They're married 20 years, 10 years, and they have, this spouse A has the kids 75% of the time, spouse B has them 20%. They could both have joint legal custody, right?
Yes, yes.
Okay, and what does that mean, joint legal custody? And that could be the same, not to interrupt you, 80-20, 90-10, but they both have joint legal custody. What does that mean?
Legal custody means the parties are empowered to make decisions on behalf of children regarding health, education, welfare, like in other words, medical emergencies, hospitals, religious issues, education issues.
Well, let's go a few at a time. The dentist, we're going on the situation 80-20, let's make it that way. Spouse one has the kids, there's two kids, 8 and 10, has them 80% of the time, spouse B 20%. You want us to believe that they're gonna have a meeting, spouse A and B, where the kids going to the dentist? Or is spouse A running the shop? Right?
Well, sometimes.
Forget what the statute says, what's reality?
The reality is sometimes when they've been married, before they came to see me in the courtroom, one of them has been the one making all the decisions. So
Okay,
sometimes you could argue that even though they were married, one of the parties didn't even exercise legal custody.
Okay, so let's-
because maybe dad always took the kid to the dentist.
Well, let's
and made
go
decisions. I
that,
don't
let's
know.
go that way for a second. So they don't have joint legal custody. Under that scenario,
Under that scenario, no.
they don't.
But
So
when
you're
people
going too
do-
fast for me.
Right.
Under that scenario, the court could give them joint legal custody, but under your scenario, well, the dad, the mom has been taken to the dentist. So with
Right.
respect to the dentist, even though the papers say joint legal custody, they really don't. Okay, what you want to add, what?
I was just gonna say, where the parties end up disputing usually is the cost. That's what usually
I
happens.
disagree. Okay, but I'm not asking that
Okay.
question. Okay, now, spouse A is a devout Catholic. Spouse B isn't. Spouse A says, hey, I want him to go to parochial school, St. Vincent's in the neighborhood. And spouse B says, I'm done with that. I don't want to do it. Spouse over here, 80%. Joint legal custody, you really think they're gonna have a meeting? You know who's gonna call the shot. Who's gonna call that shot? Again, everything is disputed here.
I don't know how that would work.
Well,
It's all different.
what would you do under that scenario? Spouse A, they both have joint legal custody, and everything I'm saying is contested. Spouse A, they live with the kids live with spouse A, 80%, 20% over here. A wants them to go to St. Vincent, Catholic. He was brought up Catholic. What are the issues that you would look at to decide?
I would look at the issues of what's in the best interest.
What
of
does
the
that
child.
mean in this scenario?
It would be very difficult to ascertain what the best interest of the child would be through the parent. Normally, in a situation like that, it would be most helpful for the court to have a guardian ad litem appointed who could address the issue of the best interest of the child.
Okay,
It's
so-
a fact.
Okay, so we're gonna get a guardian ad litem, okay? And these kids are 8 and 9. They don't know much about religion at that age. We want to go younger. What's the guardian ad litem gonna have? What are still are the factors? Whether we should send them to a parochial school or a non-parochial. They get joint legal custody. What are they looking at? I have no idea, so I'm asking you.
They could be looking at if one of the children prefer one or the other or both.
Well, they don't
Like
know. Well, let's go slow. I don't know. I don't know the difference between a parochial school and another one. All I know is my friend Johnny went to parochial school and the nun hit him, was slapped him on the wrist. I don't know.
All that becomes part of the interviews with the guardian ad litem and the children. They can be part of the report.
So other than asking the children what they prefer better, an 8 and a 10-year-old, guardian ad litem says, what do you want to go to, St. Vincent's? Or do you want to go to, I don't care, Midfield, elementary school? That's the only question? What is it? I don't know.
No, it's one of the many aspects.
That's what I'm asking. What are the 3 or 4 major questions, issues.
It wouldn't necessarily just be guardian ad litem sitting down with children saying, what do you want to do? Which church or temple or something do you want to go to?
No, I'm talking school.
Schools. It would be what the child's experience has been at that school. You would talk to the counselors of the school.
He's not in the school. We're making a decision. This is our first decision making. They're not, obviously, if they're in a school, you're more apt to stay in that. I'm making it a little more difficult.
Well, where are they going if they're 8 and 9?
Well, say they went to another school and that, they
So
went to
they'll change,
preschool.
okay.
They went to, hold here, okay,
Alright.
we gotta make it more difficult. They went to preschool. Now preschool is over, whatever, they're 6 and 7, whatever the age is. Now we gotta make a decision for elementary school.
I think then that the determination could be based on guardian ad litem discussing issues with not only the children, but the parties as to why they prefer one or the other. What's in the best interest of the children based on what's available to this child. Maybe one school is better for a particular program that this particular student has more of an affinity to. Are there special needs? Are there musical interests? Are there educational needs that are better met at one of the schools that the parents could advocate to the guardian ad litem? Guardian ad litem could present to the board. There are many factors that would be in a report regarding educational factors of children.
I gotta tell you, with all due respect, it's like, I'm not talking about kids with, you know, this is reality. I'm not talking about what's in the best interest, what school has more sport. They don't know. We're not talking 15 and 16. These are kids going right into elementary. Everything you just said, no clue. There's not a guardian ad litem can tell you one of those things. What's better education? These both schools are great. They're both in the neighborhood. What do you do in those situations? You have to make a decision. It's easy if you say, this child has got certain medical needs, and this is the best medical situation here. Or this person's got autism, and then you got 2 kids. They don't know anything about school A or B. You know what you're gonna do, but I'm afraid you're not saying. You know what I think you're gonna do? You're gonna give it to spouse A with 80%. Because what else do you look at?
I think that I would have to look at what's presented to me, other than me as a judge saying, I think we can benefit from guardian ad litem here, parties afford it or something.
Well, let's go slow. I'm sorry, but this is a big thing with me. Go one issue at a time. When you rattle these off, it's, you know, like, go one at a time again. What's important for the GAL? He's gonna make a decision. Name one issue at a time.
What the GAL is looking for is, as a fact finder, what the best interests of the children
Yeah, and he,
Right.
how does he do that?
talks to the children.
Okay, so talk. Let's go slow. He talks to him. Johnny and Mary say, I have no clue. I don't. Okay.
It's not a discussion. I've been a GAL.
Yeah.
I frequently, when I meet with kids in my office, I bring my dog to calm the kids down so they'll be a little more relaxed. I don't wear a suit, for instance. And when I meet with kids in my office, I talk to them about what they enjoy doing. I don't say, hi
Okay.
Johnny, nice to meet you. What school do you
Okay,
go
so
to?"
let's go slow on that. I enjoy sports. I enjoy dancing. Can you believe it? Most schools have everything. Most schools, there's not much difference. You know, I have 4 kids. There's not much difference between in the first grade between this school and that school. You know, so they both like sports and dancing. The schools are the same.
Is there a matter of finances that come into play?
No, they got plenty of money. They can afford that.
Right.
They can afford that. They can afford that $10,000 per open school. It's not an issue.
Right.
I'm making it hard. I'm trying to say everything is equal. What are you going to do? I mean, we can go through every issue if you want, but and you can't make a decision. They're like this. What do you do?
Sometimes the same school is good for siblings, sometimes it's not. I have cases where kids. go to
I
different
get it.
schools.
We get
So
that.
we have to look at all of them.
Yeah, but
And I can only.
now it's if it was even. Unbelievable. It was even Steven. What are you going to do? Unbelievable. It's driving you crazy. You can't pick school A or B. It's like you've done this. You've looked at it again. Who gets the edge? You flip a coin?
Maybe some people do, I don't know, I don't think so. I think you'd have to look at everything that's coming into you through the litigants, through the parties, through reports such as guardian ad litem, through the counselors at schools.
There's
That's
no
what
counseling in schools. Okay, I'll move on to the next issue. I don't think in reality it works that way, with all due respect to you. shared legal custody. What does that, oh, I'm gonna give you a tip off where I'm coming from, because I did not like your answer to Councilor Jubinville at all. And I'm a strong advocate for children. Your answer to Councilor Jubinville really, really troubled me, okay? I think, and I could be wrong, Councilor Hurley had a nominee, but I could be wrong, was one of us to the probate court. She, and you could listen to that tape or you missed it, it was pretty recent.
I did listen.
Okay, and she came, well, you know her, what she said.
I know what
She
she said.
And you disagree. She said, let me finish. She came right out and said, I told her this was the first time I haven't heard this. She came right out and said, right off the bat, I'm thinking 50-50. Custody, parenting plan, that's what my goal is. I start with that before I hear any evidence. I like a parenting plan of 50-50. That's where we start from, and then it goes from there. You don't have that.
Based on the factors that were given to that candidate, based on the factors that were given to me, I think that it would be inappropriate for me as a jurist to prejudge a case and say, I see these two parties before me. Everything's going to be 50-50 unless they hear otherwise. I don't think I could address that. I'm not thinking in those terms. I'm reading what's before me. I'm hearing the information and looking at what's coming before me. The statute does not call for presumption of shared physical custody. And like it or not, that's the law. There are some laws we all don't like, whether people want it,
What's your
marijuana to be
personal,
legal or not.
what's your personal viewpoint about, you don't know my question. What's your personal viewpoint of shared 50-50 physical custody? Forget the statute, just you. What's your personal viewpoint of people who are divorced and it's contested? It's easy when it's not contested. What's your personal viewpoint?
My personal viewpoint is, in my 23 years of experience, it has been quite successful. Shared custodial arrangements with a parenting plan for both parties has been very successful.
Yeah, but
And
I didn't ask that though. I'm talking about just you. What do you think? I don't care about all these other people. It's worked pretty well, but there are some people, even if they've had 50 cases and they all work great, it's not. I think it's awful. I think spouse A should have 80%. So I'm asking you, inside you, what do you think? What's your personal viewpoint? This judge said her personal viewpoint was that she loves 50-50. Do you have that? You may say, no, I think, it depends if they're really young, this, or when they're older, they should spend. What's your, forget the statute, forget your 50 cases, 100 cases. What do you think?
My personal viewpoint, again, is I find it to be quite successful. I've had quite successful parenting plans with the parties shared physical custody. Those are not my most difficult cases. We frequently come to an arrangement of a parenting plan, which is 50-50.
Yeah, but I guess you missed my whole point. Again, let me start again. I am not talking about reaching agreements. I'm talking about where the judge has to make a decision. I'm talking, again, all my questions, if it's I've reached an agreement, those are easy. Anyone can say yes. Yeah, I got it. I'm talking about the cases where the parties have not reached an agreement. Okay, and I know you've had it. That's what I'm talking about. Where do you come out of that? They don't reach it. I'm having a tough time from you. I tell you where I come from. My feeling is, and I'm not a probate judge, and I don't want to be a probate judge. I think for me, I like a 50-50 arrangement. I think children should spend equal time with both parents. Do you agree with that? With either a yes or no?
Yes.
You agree with that?
Yes.
Okay. 'Cause that was, okay.
That's been my experience.
I don't care about your, okay. What about someone living, again, uncontested, someone lives in Linfield and someone lives in Newton and it's contested? You still have that same opinion?
I don't think that the distance necessarily determines the time a parent spends with a child. In fact, studies have shown you're driving your kid to sports an hour away sometimes, whatever. That's parenting time. You're talking to your kid in the car.
Okay.
So I don't necessarily think that distance is a factor. Maybe it used to be years ago.
So is it a factor? So in other words, you got two kids, they're 8 and 10. The spouse lives in Linfield and another spouse lives in Newton. Is it a factor? distance, or not a factor at all?
I think it's a minor factor. I think it's not one of the major factors.
So you as a judge, if it was contested, and spouse A said, you know, it's just too far for the kids, you know, spouse B picks them up in Newton and drives them 40 minutes. They gotta get in, again, what's in the best interest of the children? That's what I've heard all day. They gotta get up 40 minutes early because spouse A comes to the house in Newton and is gonna drive them to Linfield. We're gonna do that 3 days, and the next 4 days it's reversed, back and forth. 40 minutes for an 8 and 10-year-old kid. That's fine?
I haven't found it to be that much of a problem. For instance, what I've said to clients when that's happened, and I think the court would do the same, they have no problem with club hockey. Like I said, driving an hour, taking the kids even out of state. So why should it be a problem in the schedule? It's not usually a problem.
Do you think? Well, I know my kids. I have a daughter who's a senior in high school. Oh, get up. You gotta get up now. You gotta get up. Imagine if it was 40 minutes early and this school is 5 minutes up the street. I'm not talking about the afternoon hockey. We know that.
Right.
So that would not be a factor for you going to school and getting up 40 minutes early.
I took a bus 45 minutes to Boston Latin School, and I didn't regret it.
I went to Boston Latin.
I know.
Trying to get my-
There's enough to get over the hurdle, there's one point.
trying to get my good side now.
It was bus to Mattapan before.
Yeah, I'm a lot different now. Yeah. I just don't get a sense that you're gonna be one of those judges who can convince me on an uncontested matter, on a contested matter, that parent A and B, I don't know if, I don't get the feeling that you're gonna order on a contested matter 50-50. And I'm not talking, you know what I'm trying to get at without going on and on and on. I'm talking both good parents, one parent, let's say, you'd say one parent doesn't work. One parent doesn't even work. Money is not an issue. And yeah, we know best interest of the children, all this, and
The best example I can give you to convince you of that is me, as a practitioner for 23 years, has never taken a case where a client has said, I don't want my spouse to see the kids, and this is why, if I don't agree with those reasons. If I'm not hearing factors which concern safety of the children, I do not represent them. And I've done this over and over again. And those people have left and gotten other lawyers that have taken their money, done what they wanted to do. If I don't agree with it, I don't put my name on it. So I don't think that's going to change when I'm on the bench.
well, that's good. I appreciate that. Let me ask this question on prenuptials.
Yes.
We very rarely talk about prenuptials. Now we have a prenuptial, they sign it, and one person, you know, these are 30-year-old people, I don't know how old, they're young. One person has 200,000, the other person has 25,000, everything is listed. Again, I don't do probate work, so now they want to get divorced, and we find out that one of the spouses' parents have a $20 million trust fund. Does that come into play? Can you set aside the prenuptial for that? It wasn't mentioned in the,
That could very well create an issue if the prenup is contested, as you say.
why
for
is it
example.
contested? If it's
So
not
say-
contested, it wouldn't be here.
It becomes a disclosure issue. So if it was not disclosed at the time of the prenup.
Well, that's what I'm talking about. Do you have to disclose something? If the spouse didn't know about it, her mother and father had this trust fund, they didn't know about it, and it's gonna come into effect, you know, when they're 50 or 60. They honestly, legitimately didn't know about it.
That would be a different circumstance. I thought the example.
Yeah, I understand. Yeah, no, I get that.
So if it's not a full disclosure issue, it's an inheritance issue, it may not come into play. Inheritance issues frequently don't come into play in divorce cases even, unless parties have been married a long time. So the party wouldn't necessarily share 50-50 in inheritance anyways.
I'm not talking 50-50. That issue, we finished with that issue.
Okay.
Okay. But back to you go, when you say may, I'm saying, oh, may not, oh, you don't say definitely. So back to that prenuptial. Is it automatically the other spouse would not be entitled to, not 50-50, any of that money? What circumstances? In other words, they signed a prenup. The spouse with this big inheritance coming down the road didn't know about it, but it was in effect at the prenup. He or she didn't know about it. Now they're getting divorced, and now we find out later, wow, and even the parents are still alive. Wow, so-and-so's entitled to $20 million trust fund. Can you set the prenup aside? You say may, I don't know the answer, so I'm asking you.
I don't know either, depends, and this is why. As I said, if we had full disclosure,
Okay, let's go slow on that.
Right.
What do you mean by full,
full disclosure, when we do prenuptial agreements, each party fills out
you
financial.
know, I know,
statement,
but
right? So,
he didn't know about it. He didn't know about this trust fund. That's what I'm saying. He didn't know about it at the time of the prenup.
so if he didn't know about it, and then the other party is raising it at the time of the divorce,
Yeah,
you're saying.
that's what I'm saying.
So the other party is alleging that they want the prenup thrown out under certain grounds. One would be disclosure, one would be fraud.
Yeah.
Absent fraud, I don't see how the prenup should be thrown out. If it was fair and reasonable at the time to be signed, it could be determined fair and reasonable at the time of the divorce. I think the only issue would come up, as I said, if it was fraud or failure to disclose.
Okay, what if it was like, they didn't know about, let's assume you're like John Henry, the owner of the Red Sox and this. And, spouse A and B, and someone's marrying John Henry's daughter. And the daughter only has $150,000, let's say legitimate. And this guy over here's got $200,000. But Henry's got millions, but nothing in the daughter's name. And now the same scenario, would you be able to set that prenup aside because we know he's the owner of the Red Sox and we know he's on, maybe not, because she was 100% honest. In her name, that's all there was, 150.
I think that if they both signed the agreement freely, willingly, had counsel, were not coerced, there was no duress, it was signed plenty of time prior to the marriage, it was full disclosure, it could be likely held to be valid.
Okay. All right. Percentage of cases that you handle, female, male.
Say half.
I thought you were going to say that. I do personal injury. Okay? If someone asked me, and I would say half and half, but honestly, I have zero clue. It could be 50, it could be, like, how do you know? Do you keep a chart?
No, do you know what I was surprised when I filled out my application? I was surprised that I did more probate litigation cases than I did, but I did not add up how many clients I had.
So you have no idea. I honestly have no idea. And if you say you have no idea, how do you,
I would
50
say-
is the safe answer.
No, I would say over the years, I seem to have represented both mothers, fathers, same-sex cases of men and women. I would say it's been about equal overall. in
I'm
all
coming to
years.
the end here. Retirement age is alimony payments. Retirement age generally, alimony payments stop.
Yes,
Okay. Now, what happens if someone's been married, 25 years, like in other words, a long-term marriage, a provider, the one paying alimony, gets divorced and he's 64, and let's say this hypothetical female, the mother is 59. Okay, 64, 59. And let's assume the mother's not working. She never worked. And 64, 3 more years he's going to retire, it's retirement age. And everyone's healthy. There's no kids. So in 3 years, that person's done. He doesn't have to pay.
well, the statute applies to marriages under the years of the gay. But say, for instance, we would consider that. We could consider a deviation of the statute because they've been married longer than the statute.
What would you
applies.
do? What do you look at under my hypothetical? What would you look at?
I think that.
What a factor you
I
consider?
think that it would be unusual not to take a hard look in that case of an alimony, specifically termination of when it ends into durational limits because of the age of parties. If you didn't address it, I think there'd be lots of problems with the litigants and the attorneys and the judge. So I would look at the parties expect this retirement to happen at full retirement age. The provider on the obligor would be
Well, listen,
entitled to-
I'm sorry. They don't have to, the statute, but it's just retirement age. You don't have to retire.
Right, he's entitled to retire. Nobody's forcing somebody.
No, but say he doesn't, I don't know if I'm gonna, I'm 64. I'm 64. I don't know if I'm gonna retire or not. The law says at retirement age, we can stop alimony. Would you, you're handling that case. And it comes out, I don't know if I'm gonna retire. I don't know. I haven't really thought too much about I may work till 90 and they stop in 2 years. Is the spouse entitled to alimony beyond the
In your
67?
scenario, the spouse could be because of the length of marriage.
And, because I don't know these things. Another 6 months, continuous, the way it is, you know, the old law, what do you consider?
It could be perhaps when the obligor actually does retire, or it could be that it does end upon full retirement age. It could be
No, I
serious
understand that.
factors. But I think if one party has not worked in a 25-year
Yeah.
marriage for that period of time, and if as you say, there's a significant income differential, I think that there would be alimony for a certain period of time. I'm not sure if it would end at full retirement age of 67 or something else, but certainly you would take a look at Social Security being available to both parties coming in. You would take a look at what was available to each party, and if there's a need, there has to be a need for the obligee, the person who's to receive.
Yeah, there is a need. I mean,
So-
you're making, I'm talking, you're making a lot of money. You're
Right.
making 600,000-700,000. And
So-
Social Security, what's that? 2,500, 3,000, I don't know. But you're making 500,000-600,000. Obviously, retirement age, we know that.
Right.
But how much, in your experience,